Hi, everyone. Welcome. Can you believe it? Last class, huh? Yeah. Hard to believe, isn't it? Well, I'm grateful the semester's gone so well so far, and hopefully the last class doesn't disappoint either. All right. Any questions before we start? Anything on your minds?
Yeah.
Yeah.
There was an article in the paper on Sunday about the Japanese American. It was really interesting.
What did it say?
This was talking about the man forced his own arrest to prove the curfew and detention unconstitutional under what was coming down from FDR. It's just an interesting article. It's everything we studied. So I saw it was in the paper.
Yeah, you know, this is an interesting class to teach because there's very much a moving target. Every time I teach this class, it's different. Every week, every month, indeed, every class. Different wrinkles, different flavors. And I think, unfortunately, ConLaw gets a bad rap. At law schools in general, but maybe at this one in particular, saying, oh, I don't need to know about ConLaw. Oh, I'm going to be a tort lawyer. I'm going to be a contracts lawyer. I'm going to do tax. Let me be a lawyer. And I hope I've disabused you of that notion. And if I haven't, then I suppose I failed. But this class, perhaps with others, will stay with you, I think, throughout your careers in ways you may not quite appreciate yet. But will dawn on you at some point when you're saying, oh, that's why Blackman was saying that stuff. That's why he was making such a big deal about courts and why people listen to them and everything else. But this example of what happened with the mayor of Norfolk, and if you didn't read your email, was it Roanoke or Norfolk? Norfolk, right? The mayor of Norfolk actually sent a letter urging that the Syrian refugees be detained, and he cited as an example the sequester. The sequester, which is a verb, not a noun, but the sequester of Japanese Americans during World War II. And I mean, whether he knew it or not, he cited Korematsu as a precedent to justify the detention of the Syrian refugees, or I guess the prohibition of their entry into the country. So the sorts of themes that we develop in this class never quite go away. They often arise in different shapes, in different sizes. Different parties raise it in different contexts. There's not much new under the sun. The same debates that were being had between Madison and Hamilton and between Roosevelt and the Japanese come up over and over and over again. And it's my sincere hope that you've learned enough tools in this class to deal with them not just as attorneys, but indeed guardians of the law. If you look at the founding of our country, it's no accident that virtually every one of them was an attorney. And you're entering a profession that's not just about making money and making people's lives miserable, but that you do have an incumbency, a responsibility of protecting the law and doing so. And this isn't just about doing pro bono or helping people or public defender. Every aspect of what lawyers do is about holding a rule of law and upholding the reason why people follow the law. And in your daily responsibilities, I hope and treasure that you will respect and carry that tradition forward. Everything else is, fun, but that's stuff that actually matters in the long run. Any questions?
Not really on that, but last Thursday, I had an opportunity to come and spur on me to attend the citizenship.
Oh, isn't that awesome at the courts?
I thought, well,
Where was
it
it?
was in the stadium.
Oh, even better.
People,
Yeah.
and they passed out the little constitution and the flags and all that. The whole full swearing thing I thought was very interesting. They had to denounce their country.
Yeah. So what's interesting about the oath, when you become a U.S. citizen, you take an oath to the Constitution, and you denounce all foreign allegiances. Query: how can you be a dual citizen if you take that oath? I have researched this. I think dual citizen, the oath has to be changed. The State Department has basically said the oath doesn't mean what it says. But I think oaths do. But yeah, you take an oath to the Constitution and you give up all foreign allegiances. That's something, huh? You also swear to bear arms in support of your nation, which as a member of the militia, you are obligated to do. But that was actually one of my favorite jobs of clerking. We actually had the swearing in ceremony at the courthouse, and I would always give all the newly founded Americans little constitutions. It's nice. It's a nice thing. It's one of the rare times people go to court for a happy occasion. Usually people go to court for a sad occasion. Very rarely do you go to court to be happy with people with their families and kids and taking pictures. There were no selfies back then, but I suppose there are now. Cameras weren't long enough yet. Other questions? All right, so for our last class, we will focus on the First Amendment religion clauses. Again, I could do an entire class on like these 6 words of the Constitution, but I can't. So you get 2 hours. So we start, as we always do, with the text of the Constitution. And the Constitution says that Congress shall make no law shall make no law prohibiting the free exercise thereof. It also says Congress shall make no law respecting the establishment of religion. So the first jarring conclusion to anyone who's ever heard anything about government is, where's separation of church and state? It's perhaps a shame of our public education system, teachers in the company room excluded, that everything that people know about the Constitution of religion is separation of church and state. And you'll find that the phrase appears nowhere in the Constitution and was not uttered by a single person who signed the Constitution. This was a phrase that President Thomas Jefferson, who was in Paris while the Constitution was being ratified, he was overseas. It was a phrase that President Thomas Jefferson wrote in a letter to the Danbury Baptists, where he describes a wall between church and state. The context of this letter had nothing to do with how it's used today. But it's often said that, we need to have a church in one hand and state in the other. So as an original matter, that's bunk. Why? Because at the time of the founding, several states had established churches. Massachusetts, among others. States had established churches. So what does this mean that Congress should make no law establishing a religion? This is effectively a federalism provision. This was saying that Congress cannot interfere with the state-run churches. Imagine that. Congress cannot disestablish a state church. This is a fear that there'll be a single religion nationwide, and that each state could then choose their own faith. This is what the phrase means. This is not even controverted, right? This was designed as a means to prevent the federal government from interfering with state churches. Go figure, right? So the only clause in the Constitution that the separation of churches is based on has nothing to do with that. So what happened in the subsequent 200 years is a different story. The court has indeed interpreted the Establishment Clause to apply not just to the federal government, but to the state governments as well. Indeed, Justice Thomas stands alone as explaining that the Establishment Clause cannot be incorporated. That's actually a federalism provision that was designed to protect the states from being intruded upon, but that view has not carried the day. So I don't spend too much time on the Establishment Clause because it's an absolute mess. You look at cases where the Supreme Court said that the 10 Commandments on the grounds of the Texas Capitol in Austin, which I'm sure you've seen, that's constitutional. But the 10 Commandments on a piece of paper inside of a courthouse, that's not constitutional. This is what the Judge Clifford called the 10,000-pound rule. Something weighs 10,000 pounds is constitutional. If it's a little piece of paper, it's not. This is not a rule of law. You have cases involving whether you can say prayers before high school graduations. You can say prayers before football events. Whether you can say a prayer before a member of a legislative council, a city council meeting. The case again here is quite muddled. And one relevant fact point is that one of the first acts of the first Congress was to actually hire a chaplain to say a prayer before the legislative session meets in Congress. Indeed, to this day, every single day, a chaplain of a different faith reads a prayer before Congress becomes in session. Okay? If you want to look at what the founders thought about faith, you can read things by George Washington, his Thanksgiving address coming up in a few days quite fittingly. So I really don't teach the Establishment Clause in my brief time because it's an absolute mess. It's entirely and utterly divorced of history, but these are the cases today, and they're not consistent. The cases are all over the place. There's no single test for establishment clause. It's very muddled. So I will leave that here. But I do want to focus on the second one, that Congress shall make no law respecting, or prohibiting the free exercise thereof. What does that mean? Congress shall make no law prohibiting the free exercise thereof. By the way, thereof refers to religion, back to the first clause. So the meaning of this phrase is actually very difficult to grasp. So, okay, you remember where I finished last time? God, I don't remember. All right, Ariel, sorry. What does it mean to prohibit the free exercise? What, in plain language, forget about the Supreme Court for a second. Just you look at the language, to prohibit the free exercise of religion. What would that mean to you? Well, where do you get hindered from? What's prohibited? Forbidden, right? So what would that language mean to prohibit the free exercise of religion? What does it mean to prohibit the free exercise of religion? We wouldn't be allowed to do what? Like what, for example? Go to church. Okay. Well, so let's try this one. What if the state said you're allowed to go to church, you're allowed to, pour sacramental wine, but you can't profess a belief to Jesus, Allah, Muhammad, Buddha, whoever you want? What are they prohibiting? You can exercise your faith, you can go to church, go to mosque, do whatever you want, because you can't pray to a certain deity.
But that's an expression of
Oh. So this word exercise, right, can be understood in two different facets. On the one hand, you have what I call spiritual, right? How I connect with my maker. My personal bond with whatever the Almighty is, whoever he or she or it or they or whatever happens to be. But the other facet is doing stuff, right? Religion is not simply about having a mental state. There are certain acts that are associated with religion. Going to church, pouring sacramental wine, lighting candles, performing animal sacrifices, in case of Santeria, we'll get there later, right? There are various means of exercising your faith. Beyond just the conscience aspect, there's also the aspect of the acts. But the inherent tension arises, right? And this is the debate that Madison had. It's debate that we have today. Is what happens if a person's actions that are consistent with their faith are something the state wants to regulate or prohibit? I think we would all agree that Lindsay's right. The state can't tell you, you cannot have a spiritual connection with this deity, right? That's a no-no. But what if the state said, you can pray to whoever you want, you just can't use sacramental wine because we have prohibition. Or you can't use peyote because it's a narcotic. You can pray, just you can't do that sacrament, you can't do that ritual involving lighting or conducting animal sacrifice. The question of whether we carve out exceptions to generally applicable laws is at the cornerstone of the free exercise clause. We have not had a case where the government has said, you can't worship. We have had cases where the government said, you can't do certain acts which may facilitate your worship. Okay? So the text of the clause doesn't help us, right? No one's actually prohibiting the exercise of religion. What the cases always involve is whether acts which are done in pursuant of your faith, of your conscience, may be regulated by the state, or if the free exercise clause demands an accommodation, yes, a religious accommodation where you're exempt from certain requirements that would indeed burden your faith.
So atheists.
I'll get to atheism on my next question, but sure, go for it.
Well, I guess so. You're talking about acts, but yet so many of their cases are about removing "In God We Trust" from a dollar bill.
Well, those are establishment clause cases, so keep them separate. Those are the cases saying that the state cannot establish religion. Case involving the Ten Commandments, "In God We Trust" and currency, prayer before legislative councils. That is establishment clause. That is separate apart from the free exercise clause. You have to keep them separate. What about atheists, right? Maria, what about atheists? Person who believes in no God. Is that a religion? Being an atheist religion? No God? Who gets to decide what a religion is? I get to decide what the faith is. Do you, as a court? What do you think? Who gets to decide what a religion is? For example, well, that's fine. I can decide for myself. But what if someone else doesn't agree with me? Who should courts be in the business of deciding what is not a religion? Why not? Maybe they will, maybe they won't. Hey, Adriana, you ever heard of the church that flying spaghetti monster? I'll come back to you, girl, you're laughing. You ever heard of the church that flying spaghetti monster? Who's heard of the church that flying spaghetti monster? What is the church that flying spaghetti monster?
We actually deal with them a lot. So essentially, it's kind of a satirical religion.
Oh, be nice, be charitable.
I'd be charitable. I'll call it satirical religion. I'm using his own words, the founder. So it's a satirical religion to where the deity that created everything is the flying spaghetti monster, and everything that is good in life is based on his evilness. They were spaghetti colanders on their heads, and to try to kind of like, I guess, if I was in Israel, I'd wear a yarmulke. And it's just ridiculous. So they're actually suing us right now.
Why are they suing you? Oh, this is perfect.
They want to wear a colander on their head. They won in Massachusetts actually last week. So just came across a Massachusetts driver's license with a colander. This is legit. They're suing, saying that this is my religion.
Now I'll come back to Adriana. Okay, now that you have that essential knowledge, right? A religion was founded. I mean, not all religions are old. I mean, there are certain religions that are quite recent, right? Mormonism is, 150 years old? I mean, they're good religions. They pop up. And this is indeed the church, the flying spaghetti monster. And instead of wearing a yarmulke or what Jews wear a kippah on their head, they wear a colander. You pour hot water into making pasta to worship the noodleness, right? And they demand as an accommodation that in their driver's license photo, they wear this colander on their head. Now, usually, if you're ever into the DMV of the driver's license photo, they say you can't have any head coverings, right? Why? Well, they want to make sure you can identify yourself with your photograph, right? They want the photo to be covering you. You can't have your ears covered or anything else. If you have a passport photo done, there's very specific guidelines, right? But they say, no, I cannot take off that colander. So they sue. They sue Aaron. Is this a religion? Well, assuming you're a judge, right? Is this a religion? Is a judge going to say this is not a religion? You don't think the court can say it's not a religion? Why not? So here comes the issue, right? For a court to define whether something's religion or not is a very messy enterprise. It's a very, very messy inquiry, right? Who am I as a judge to say this is not a religion that is? Christianity, good, spaghetti monster, bad, right? Who am I to say? Does it matter if they only have a couple hundred adherents? Does it matter that their God is a spaghetti meatball monster? This is their faith. Now, the follow-up question, okay, let's assume that this is indeed their faith, and we can substitute now a colander for a burqa. Because indeed there are cases where Muslim women refuse to take off their burqa when submitting for a driver's license photo. Now, a burqa, depending how it's structured, leaves very little of the face open, and it defeats, in many respects, the purpose of identification, because you can't see the person's face. So do we tell the person, you know what, no driver's license for you? Or do we give an accommodation and allow a driver's license photo which has, a little eye slit? They can see, what do you think, girl? Islam will say is a religion that is not some sort of satirical faith, right? Can a court decide that a person's religion should be burdened enough to make him take their burqa off in a driver's license photo, assuming they're allowed to drive whatever it is with, can they do this?
If they have some sort of basis to do this.
They have a sincerely held belief that they cannot take that burqa off in public. That is simple. It's sincerely held. There's no doubt about that.
How do you want to say it's interest?
Okay, what's the state's interest?
I don't know how to use it. Recognizable.
Having accurate.
I guess it's not.
So can the state burden their faith, or must the state offer them an accommodation?
They can in that case.
They can what?
Burden their faith.
Just what do you think? Out louder, I can't hear.
I just think it
Just let me ask you this question. Let's say you're let's say that there's an applicant for a job at Abercrombie & Fitch, which is a store you may know of. It's a very trendy hip store, and they have very strict guidelines of what their associates wear. And one of their guidelines is no headgear. And a Muslim girl applies for the job. She's otherwise qualified, but she's wearing a covering on her head. And that's part of her religious faith, to wear that covering. Okay, so let me ask you a different question. Let's say the facts were such that, I don't know. Okay, let's take a Sikh person, for example. Debbie, let's take a Sikh person, right? And part of a Sikh's religion is something called a dagger. Well, the heck of it, what's the name of it? A kirpan, is that the name of it? It's basically this blunt dagger. And that's part of their faith. This was carried around, right? And by all accounts, it looks like a weapon, right? I mean, I know it is, you know it is, but if anyone walks through, it's a weapon. What if an employer said, well, I don't want you having a weapon in public, even though it's blunt, it's like a fork, right? It won't hurt anyone. Can an employer say, as a condition of employment, we don't want people carrying weapons, not singling out Sikhs, but then you can't bring this dagger on your belt? What do you think?
Okay, so I have to think about it because there's this state's compelling interest
Good.
against the religious practices, because we're not talking about the belief, we're talking about their behavior.
Good. Yeah, good.
But then there's also the private party interest.
Okay.
So, where the state has a compelling interest, as we talked, if the woman has her driver's license photo with her burqa and you can't, for purposes of identification or whatever. But between private parties,
Mm-hmm.
Certainly the organization employing the person has a right to define some standards, but it's gray area, right? Where do you draw that line?
Aren't these questions
And
tough?
that's- What is it? Reasonable parties can disagree. So
Mildred, let me ask you another one. Let's say this actually was a recent case. So there was a Muslim cab driver, or no, sorry, Muslim truck driver, and he refused to haul alcohol because alcohol is prohibited by Islam. He was fired from his job because he refused to haul alcohol. And he was a truck driver, and whatever, he has to haul alcohol.
So in that case, did they give any type of reasonable accommodation where he runs other routes and falls under the thing?
Well, let's say sometimes they can, sometimes they can't. Right? Depends whatever the load is for the day. If the load of the day involves some alcohol convenience stores, that's what they have. Let's just make it easier. Let's say it's a government employer, or the private government employer, right? He works for the state has a whole truck, and sometimes they have to bring alcohol to state lodges.
I understand the portion of it where yes, he's applying for a job and realizes that he may have policies and questions and you have to be aware of what you're applying for. However, if a reasonable accommodation can be made, I don't see where.
Okay, I'll give you another one. Let's say the same guy applies to be a bartender. He says, "I'm only going to dispense soda. I won't dispense,
Do you apply to be a bartender and only dispense soda?
Well, the actual example, the flight attendant. There was actually a woman who was of the Islamic faith, and she was a flight attendant, and she actually, like I said, I'll only dispense soda, and she actually made her colleagues do a double alcohol. They were not happy because that's twice as much work. She be terminated.
Still think she should be terminated. She probably should be.
Every airplane serves alcohol and soda in every cart. There's a case fairly recently. I'm not making examples up either.
And how does it work?
I don't know if that one's resolved. I can Google. I think that one still might be pending, but I think that was filed somewhat recently. Your hand up?
Yeah, I just wanted to add something, because I'm noticing the examples you're bringing up. I see it as there's an issue of control.
Mhm.
Like, who is the person that their religion, they don't believe in drinking liquor to tell another company, like a norm, to give out
Okay.
liquor? They can't.
So if you notice, I didn't give an example involving, let's say, give me an example. So one of the aspects of free exercise clause, I think the man has a good point, involves what we might call norms, right? In a society where certain religious beliefs are tolerated and considered non-controversial, people of the majority faith aren't usually tested, right? I say it a different way. If we were in, let's say, Saudi Arabia, where alcohol is illegal, or it's supposed to be illegal, right? A truck driver wouldn't have this problem. Or say if we were in, I don't know, Israel, where pork is basically almost impossible to come by. And if you were a truck driver in Israel, you wouldn't have to worry about having to haul pork. But in the United States, both pork and alcohol are quite legal and available in supply. So this is actually the point in the dissent in Point Division versus Smith, which I'll get to in a few minutes, right? The democratic process is good at making carve-outs. I'll give you an example. During Prohibition, sacramental wine was legal. During Prohibition, there were specific carve-outs for sacramental wine. Why? Well, enough people were Christian that they were able to obtain special dispensation for sacramental wine. The same circumstance did not prevail for peyote, right? You have a prohibition on alcohol, but there's a carve-out for sacramental wine. However, with Native American peyote, there was not a similar carve-out.
Would the idea that the purpose of prohibition was to stop drunkenness versus sacramental wine being specifically for the religious service and
It's alcohol.
intended to be drunk on, like
It's alcohol.
that wouldn't make a difference though, as opposed to
It's alcohol.
like the purpose of ingesting peyote is
You got a constitutional amendment prohibiting alcohol, right? This is a high order. Debbie.
And it's like the example of having to go to court on Sunday.
Ah,
For the Seventh-day Adventists.
good.
You want to go on Saturday, and it wasn't ever an issue for the Christians because you didn't hold court on
Even better example I was thinking of, right? Even better example I was thinking of, right? So this is the issue. If the democratic process enacts laws that respect certain faiths, those never get to court. So one of the cases involved today called Sherbert versus Werner, which involves Seventh-day Adventists. The facts of the case, okay, so Seventh-day Adventists, they celebrate the Sabbath on Saturday rather than Sunday, okay, like Jews. So, by the way, in New York City, they lived in New York, you usually don't pay parking meters on Sunday, right? But in the Jewish neighborhoods, you don't pay parking meters on Saturday, under the Sabbath. Why was that dispensation there? Well, again, Jews actually vote in New York. We actually have a demographic. And indeed, public schools in New York get off for most of the Jewish holidays as well, which I don't, do they have them off here? I don't even know.
They
Is
had it this year.
that new? Oh,
Yeah, and
okay.
I think they will actually give individuals like a
Special pass? Yeah, but in New York City, on Jewish holidays, schools are closed. There's no ifs, ands, or buts about it. But Debbie's point is actually very well taken. So imagine this, right? You're a Seventh-day Adventist, and your religion says, I cannot work on Saturday. Okay, so you're applying for unemployment benefits, for unemployment compensation. And you say, listen, I'm willing to work any day of the week, but Saturday, give me a job on Sunday, I'm going to work on Sunday. And the city says, wait a minute. You don't get to pick and choose. Our law says you have to be willing to work Monday through Saturday. Our law gives you off for Sunday for the Lord's Prayer, right? But we expect you to be able to work Monday through Saturday. If you're not willing to work on those days, you are ineligible for employment compensation. You're ineligible for benefits. So this case went to the Supreme Court. What did the court hold? The court held that the Seventh-day Adventists won. That this law imposes a substantial burden on his faith. Right? It's basically giving him a choice. You can either get your employment money or go to hell. I mean, not in those words, but you can force a person to violate his deeply held religious beliefs as a condition of getting these benefits. Right? So we do have this tradition, or at least this precedent, I should say, where various claims based on religious beliefs are afforded accommodations, where usually the law says you have to work Monday through Saturday. This guy gets a court-imposed accommodation. Now, but Debbie's point, though, was a little bit different. It's more refined. A Christian who celebrates the Sabbath on Sunday wouldn't need a court decision, right? The court decision exists for the minority faith who would not be able to channel the political process to achieve that goal. You see similar things with the Yoder case, the Amish students, right? The Amish are not a powerful constituency in Wisconsin that they can lobby the legislature to request an accommodation by statute. They go to court. The Native Americans in the Smith case, right? You may say they're not quite influential enough to go to the political process to receive a statutory accommodation, so they go to courts. Actually, as a coda, afterward, subsequent to Smith, Congress, in fact, did pass a statute legalizing peyote for Native Americans. So that narrative doesn't quite hold up, but I think it's good enough. So, at least in its early stages, the Free Exercise Clause served as a reinforcement for various minority faiths in a largely Christian or Judeo-Christian nation. But one of the most fascinating aspects of Free Exercise Clause law in the last 10, 15 years is how this has shifted. And if you want, I wrote an article on this called Collective Liberty, which goes into this in some depth. But in many respects, cases that were designed to protect religious minorities as a sword have been shifted in many respects. Cases designed to protect religious minorities as a shield have been shifted in many respects as a sword unto themselves. So whereas you once had a fairly homogeneous society enacting laws that respected certain religious norms, that is not any longer the case. In fact, our society is trending quite secular. If you look at the numbers, youths today, right? The kids today are far less religious than their parents, and those numbers are going down significantly. So it's not surprising when laws are being passed that, in many respects, intrude on traditional religious values. And Exhibit A might be the Hobby Lobby case, which I had you read a little bit about in your reading. Hobby Lobby is actually complicated because Mildred Obamacare, the contraceptive mandate's nowhere in the law. In fact, the contraceptive mandate came from the regulatory agencies, which I think lack the authority to make those accommodations, but the law itself is silent on it. But we'll put that aside for the moment. But when you have a society that's becoming less secular, the groups who are availing themselves of the free exercise clause become those who perhaps didn't need it in the past. And so today, the groups who are seizing on the free exercise clause in RFRA, as you'll read about, are traditionally Christian groups who are finding themselves no longer in the fold. In fact, Pope Francis had this great quote in his last visit to the United States. And he was talking about the marriage decision. I'll see if I can find it. I want to get the quote right. I don't want to. Francis. Here we go. Hopefully this finds it. So Pope Francis actually had this quote where he, let me find it. I can't find it. I'll get it later. And he actually effectively said something like how for many years, the teachings of the church were largely consistent with the teachings of society. That is, the church favored traditional marriage as its society. And Pope Francis basically said, that's not the case anymore. And I think he's quite right that in many respects, the traditional religious mores and those of society are passing like two ships in the night. And it's going to be very significant to watch as that gap becomes larger. And as the democratic process embodies less protection of faith. And I think I mentioned this when we discussed the Burwell. What happens if a city starts saying to a church that refuses to perform gay marriages, we're going to take away your tax-exempt status, no more property tax-exempt status, because you're discriminating against gays and lesbians. You're free to exercise, right? You still can exercise however you want, pray to whoever you want, but you don't get any benefits from the state. They're not singling out any religion. They're simply saying we have a law that applies to everyone, no discrimination. Is there anything stopping that from happening? Not really. The democratic process and what people vote for is the only cabin check. And in certain areas of the country where faith is not particularly important, these sorts of laws, I think, will continue. Yeah.
So how does taking away someone's tax exemption, for example, let's say the diocese here in Houston, how does that affect their manner of, in the sense of discharging it?
Does it?
No, it doesn't.
Doesn't? No. Does a church need a tax-exempt status to pray to God? So why are churches given tax-exempt status historically? Anyone? Why historically have churches given tax-exempt status?
Because of the work they do for the community and the certain.
But why were they considered nonprofit?
I'm just backing up what he's saying.
It was a thinking that religion is good for society, right? That this is something that we want to encourage, that religion actually helps society. That is not always going to be the perception. And in fact, many people think that religion is a negative on society. There was actually a study done in Australia. I mean, things happen in Europe and abroad, come here 10 years later, that's usually the trend. There was actually a study done in Australia simply saying that the mere fact that an organization is a house of worship does not mean they should automatically get tax-exempt status. The report said we should actually question, in fact, if they are contributing to the public good. And if indeed they are finding that they're discriminating against members, but not even gays, whatever else, that outweighs the good. This is a report I blogged about last year. It was an Australian report on reforming their charity laws. So stuff usually trickles over, 10 years later. So the question is whether the exercise of religion remains as an important element society actually values. If it doesn't, well, they can remove their tax-exempt status. And by the way, if churches can't accept donations, they go to business very quickly. They can't thrive as a tax entity. Most houses of worship barely keep their membership doors open. If they actually start paying sales and property tax and income tax and everything else, they don't make profit. That's not what they're there for. They go out of business pretty quickly. So no, would it prevent them from discharging their faith? No, but Joel Osteen would have some difficulties by maybe have to get a job at Costco. I don't know. Anyone else? I saw a few hands up before.
I'm sorry, I had one more question then.
Yeah.
Then flip it.
Flip it.
How would Madison think about, in a sense now, his whole thing was not having the states create religions, but would he not think those exceptions, those carve-outs, in a sense, within acknowledging?
So let's talk about Madison, right?
endorsing religions?
So Madison's memorial remonstrance was probably one of those famous statements of religious liberty in the early years of the Republic. So it's framed by James Madison, the same person who helped draft the First Amendment. And in short, Madison objected to a tax that was imposed on Virginians, which we used to pay for specific houses of worship. You can choose whatever house of worship you want, or you can simply direct the money to a general learning seminary, whatever it was. Where's that to? Elizabeth, what was Madison's problem with this taxing regime? Louder. A dangerous abuse of power? Why? But how is taxing someone force them to choose how to worship? They don't have to believe anything. They give a tax. They don't have to believe anything. You're not forcing them to believe anything. How? Listen, I write my tax dollars every year. That money goes to a lot of things I don't like. I mean, our tax dollars go to a lot of things that we don't like. Pick it up wherever you want. But there's a lot of things the government pays for that I don't like. Is my conscience being violated, Gil?
Just because it's based on the idea of tithing and the requirement that it goes specifically to a church.
Oh, so does it matter? Does it matter if the tax is right to a church or just goes into the general treasury and it's chopped up every which way?
And I think it matters because it goes to the government that it's going back to the people in some form or fashion, but it goes to the church. It kind of puts a regulation on maybe you don't want to go to a church, maybe you want to go to a mosque or to a synagogue.
Maybe. Walter, what do you think?
I think contradicts some people's religion or what religion they are. Let's say you're Catholic and your money goes to Jewish community, or let's say something a different religion community. So I see that conflict with a person's views.
I think what Madison was concerned about is that the moment the states get involved with this taxing based on funding churches, it was the whole point that the government was involved with a church entity.
But
But
I said at the
He thought they
time,
should
states
stay away.
established churches. States had established churches.
But he thought the state should stay away from religion as a whole.
Mm.
Right out. And because the moment you could say you can collect it for the churches, then that gave the states power over the church. And in turn, it could become a much stronger, give the state more power. Because then it could say, you know what, we're just now decided we're going to just tax this religion.
Mm.
I think it started creating too much power given to the state.
Debbie?
Well, isn't there the element about mandating the way in which you practice religion? I mean, so I'm gonna mandate that you give, what was it, 3% or whatever to your church, or 10, your tithe, or 10%, whatever. And I may want to give 7, or I may not want to give monetarily. I may want to give some other way. Isn't it about?
But didn't they always have the option to give to a general seminary of learning? They didn't have to give to any church. It's a tricky one, right? Because the tax dollars which you and I spend every day, if you go buy something, you go pay your income tax, whatever, that's being spent on various religious things. And by the way, a tax exemption is a subsidy. I know you don't think of it. Giving a church a tax exempt status is giving them a subsidy. because that money is not coming to the tax base, so other taxpayers to make up the load. The tax exemption is a subsidy. There's no, if you don't charge a church tax, that means other people pay more. The money doesn't materialize out of thin air, right? So it's not just giving an exemption, it's giving them a subsidy. And the debate and the memorial remonstrance is still happening 200 years later. Still happening. That's why I said nothing. There's nothing new under the sun. Nothing new under the sun. The same stuff Madison and Henry are arguing about, still going on. All right, any other questions on that background? I'm not trying to resolve the debate between Madison and Henry because it's beyond resolution. So let's go into the first case. Mark, let's talk about Wisconsin versus Yoder. What were the facts there?
Well, the state of Wisconsin basically made it, you had to attend high school at a public school. They made it compulsory. And the respondents were members of the Amish faith that did not want their children to go to high school because it conflicted with their own personal religious beliefs. That high school basically taught them to be competitive, taught them to be a little more worldly.
Worldly, oh wow. A little bias seeping in there, just a tad, right? Thank you, Mark. Very good. So, has anyone ever been to Pennsylvania Dutch country? Okay. The Amish, or if you ever watched Weird Al's Amish Paradise, right? So, the, no? You know the video Weird Al, Amish Paradise? Google it after class if you haven't seen it. It's really good. So the Amish are a religious sect, and they are they take literally the Bible that you should basically not depart from the ancient way of living. So they shun electricity. They don't use modes of transportation. They dress very plainly. They're basically all farmers and various professions. In fact, the biggest issue with the Amish, with their modesty, and this is a big case in Ohio, is that they refuse to put on the back of their wagons reflective tape, because reflective tape is considered immodest. And the state of Ohio passed a law saying all vehicles must have reflective tape on it, so that way if they're riding at night, they don't get hit. I went to Penn State. I once got cut off by a horse and buggy, right? They're actually very belligerent. They actually passed me on the right, and they came around me. I couldn't believe it. I was in a car. It happened. I swear. I was like blown away. But they kept on the side. They kind of went around me. I was like, all right, fine. I'm going too slow. But they object to being put on this reflective tape on their car because they're supposed to burn. So the facts here are a little bit different. The facts here was that the state of Wisconsin said, we will fine you with $5 if you refuse to send your children of a certain age, 16 or 17, whatever it is, to a high school. Okay, so Yvette, why did the state enact the law? What was the state's interest in this law? Why would the state enact this one? Why would any state have compulsory education laws? Best interest of the child, and who else? Yeah. The state, I think most people would agree, and I have several teachers in the room, has an interest in having an educated populace. If you have a educated populace, they can advance more in life, they can have more careers, they can make society better. Indeed, we discussed in the various desegregation cases that public education is fairly new. It only came around the 20th century. So Wisconsin says, we're going to require people to go to school. Now, Aaron, if you have to guess, which groups do you think the state was worried about when they passed this law? Do you think they were trying to target the Amish?
Necessarily trying to target.
So why would they put a $5 fine? Who do you think the state was thinking this fine would actually serve as an incentive?
Poor people, migrant workers.
Farmers, right? Farmers who want to keep their kids at home to work on the family farm. And this is why originally we didn't have school year-round. School is off in the summer and the fall for harvest, right? So the thinking was, let's pass this law and we'll penalize, poor farmers probably, to keep their kids in school, right? If you're wealthy, you don't need to keep your kid in a farm. You can put your kid in school. but this was meant. So Aaron, but you hinted before, do you think there was any animus or any motivation to target the Amish with this law?
I don't see that they were necessarily targeting them.
Okay.
I see that they probably knew that the Mennonite community was.
Amish and Mennonite are very different.
Oh, okay, sorry. The Amish would.
Mennonites actually drive. They just dress in the function. They're actually
So the-
Pennsylvania. You know these things.
that there would be.
I once saw a Mennonite person working at Burger King. It was very interesting. They dress like Amish, but they're not.
There's actually an Amish person working downtown.
Yeah? Okay.
They probably knew that it was going to be an issue of some sort.
But do you think the motivation for this law was to punish the Amish? All right. So here, this is what we might call a law of general applicability. A law of general applicability. What does this mean? It applies to everyone equally. If you have kids at the age of 17, regardless of what your faith is, you have to send your kids to school. There's no ifs, ands, or buts about it. Okay, everyone get that much. All right, so what happened? Poor Mr. Yoder and poor Mr. Yutzi decided not to send their children to the past 8th grade to high school, and they were fined $5, right? So Johnny, what did the Amish plaintiffs ask? I'm sorry, it was actually a criminal case. What did the Amish defendants ask for in this case? What was their goal?
To not be fined.
What did they want?
Money back?
No, I'm sure they want their money back, but what did they want with respect to this law?
Oh, for it to not apply to them,
What do we call that?
an exception.
An exemption or an accommodation? But they're close enough. They basically wanted an exemption from the law. They said, look, this law, it's general, applies to everyone, but it burdens our faith. Therefore, we want to carve out. We want our faith to be exempted from this law based on our religious beliefs. So Naquanda, what did the court do here?
They say that the state had more.
The state had more of a compelling interest? Who won here?
Did the state win?
Do you know?
I don't know.
Amanda, who won here?
Oh, it was, they ruled in favor of the Amish.
Okay, why did the Amish win here?
Well, I don't know, I believe, I guess it was the idea of homeschooling in a way that they would be able to preserve their own home. Like, they'll have their different options.
Okay. What do you think, Sophia? Why did the court rule in favor of the Amish here?
I think it's something like their beliefs were so tied to their religion, you would be burdening. Things would be a burden on them.
Good. So this is the case where they try to unpack the two facets of free exercise. You have the spiritual, the faith, and then you have the actions, right? No one here is telling the Amish that they can't worship God in whatever manner they choose. What they're merely telling the Amish is that you're obligated to to go to school in this manner. So the question is whether the action so intrudes on the religious beliefs that itself violates the Constitution. Uncle, where was your kid last week? I was waiting for him.
They got a babysit.
Oh, okay, I see.
Question.
Yes, sir.
Is that not though the slippery slope from Aaron's
Spaghetti monster.
and people?
Yeah.
Okay. Because isn't the court in some way deciding? In other words, they say deep religious conviction, which is Amish folk.
No doubt they're deep. No doubt they're sincere,
And
right?
There is, but
Oh, do you doubt they're sincere?
I don't doubt that they're sincere. But my question is, are they any less sincere than wearing a calendar on my head?
What do you think?
I don't believe they should be. In other words, if this is, it's just like the Church of Lucifer guy that just started the church a couple of weeks ago. This is my.
Well, let me give you a better example, right? The Quakers are pacifists, and they object to war. While the draft was in effect in Vietnam, a lot of people became Quakers. I'm not joking. A lot of people said suddenly, yes, I want to be like the guy in the oatmeal jar. I want to be a Quaker, right? Ansel, can the court there say, you're not sincere. You're just taking this because you want to get the draft.
So, I mean, that's a slippery slope.
So here the courts are very skeptical of challenging the sincerity of beliefs. But you can imagine if someone seeks a draft exemption claiming that they're a Quaker, and they only adopted that belief on the day they were drafted. Can a court not say this is BS, that you're making this up to stay out of the thing, right? In other words, these guys were Amish for generations and generations, right? There's no doubt they've lived a life. Well, someone simply adopts a religion overnight, right? I'm in the church of pacifism. I just made it up. Does that not be a religion?
It should be. I mean, in theory, not that I want to get into this, but if you accept Jesus Christ as your Savior, the second you do that, you're saved. I don't need generation. I'm saved when I say I believe in Jesus Christ.
Take a dump in the baptismal pool, and you're good.
Good.
You're good.
I don't need generations.
Just assume.
I don't need generations.
Right.
Who are you to tell me that wasn't as sincere for me as an Amish guy for 70 years?
So what the courts, interestingly enough, the courts are not willing to second guess what the tenets of our faith are. Okay? They're not willing to second guess what the tenets of Islam or Amish or spaghetti monster is. But what they have settled on is testing whether you sincerely hold those beliefs. The courts have said among the two inquiries, they're more comfortable deciding whether you sincerely hold beliefs rather than deciding whether these are actual beliefs of religion. Because objectively, as a matter of evidentiary privilege, you can decide how long you've been doing this, right? Is this a belief you sincerely held? What if you suddenly dunked your head in the baptismal pool the day you were drafted, and you had no indication that this was something you wanted to do before? Is this an act of convenience or an act of faith and conscience? This came up a lot with the draft objectors. Seriously, all these scruffy-haired hippies became Quakers overnight. It's magical, right? Get a little too much oatmeal, I guess.
I had a quick question, and I know when we hit Smith, I just want to,
We'll get there.
I'm sure we'll go back to it, but you said here is a rule that was established for all people with a, I guess what you would call a compelling state interest of everyone being educated, not meant to target anybody.
Mhm.
Just when I was reading them and I hit that, it seems really conflicting with the decision in Smith.
Why? Whoa. So Yoder represents the high point, right? Yoder represents the high point of protection for religious liberty. What happened from Yoder to Smith is a reversal. Smith, although it didn't say so, effectively overturned Yoder. Smith, although it didn't say so, effectively overturned Sherbert v. Werner, the Seventh-day Adventist case I mentioned. It didn't really, but it really did. So that's why they're in tension. Okay, but just to dwell on Yoder just for a moment longer, the court says whether your religious exercise is belief or action, the state cannot punish it. You'll recall that Justice Douglas, who I've beaten on of late, remember he tried to stop the war in Cambodia, and he thought that trees have standing, and the penumbras and the emanations, and and the New York Times versus Sullivan, what did he dissent? I can't remember, so many crazy cases. He basically said, and interestingly enough, that the right issue here is whether the parents can deny their kids an education, which has nothing to do with the case. But he dissented anyway. Justice Douglas, go home, you're drunk. That's actually my notes. That's what I wrote. If you don't believe me, it's in there. Anyway. Dude was nuts. Okay. Yes, Lindsay?
I'm sorry, maybe I read it wrong, but I thought the dissent was more like that the kids weren't taken into consideration. Like their
Oh. Oh, so who has an interest in the children, the state or the parents?
Well, both did.
Oh, what about Meyer v. Nebraska? What did Meyer v. Nebraska say? He examined how many days?
What did it say?
That was the case where the state tried to prohibit the teaching of German in schools.
Okay.
Or Pierce v. Society of Sisters.
Well, I guess what they were talking about for sure. Like if a child decided they didn't want to be Amish, would they be deprived
Lindsay, as a matter of law, you a teacher? No, okay. But as a matter of law, before a child turns 18, who gets to make these sorts of decisions? Why? Well, no, it's not just Rugrats. Myra, Nebraska says that parents have a constitutional right to direct the upbringing of their children. Remember those cases? So this isn't just a matter of the police power, right? Generally speaking, parents have a constitutional right to direct the upbringing of their children. The issue of whether it can be compulsory education is always subject to the parents to decide how the education is provided. So here, interestingly enough, the question is, can the free exercise clause trump the state's interest in providing education? And, you know, on the one hand, you have a constitutional right. On the other hand, you have a state interest of, you know, some importance.
But I still agree with the decision. I think it came out right in favor for the family.
Mhm.
I just thought that the dissent was more than nonsense, because I could kind of see from whence they came.
Yeah, maybe my criticism, this wasn't issue raised anywhere in the case. It wasn't. That's why it was so hard on Justice Douglas, but I'm all day. Other questions on Yoder? All right, let's move on to Smith. The facts of Smith are actually quite interesting because you had a guy named Al Smith, you know, a real Native American name, right? You had a guy named Al Smith who was working as a drug counselor of all professions in Oregon. And he rediscovered his Native American faith. I can't recall how he was brought up. I think he came to his faith later in life. And part of the religious rituals of this Native American group was to ingest peyote. Everyone know what a peyote is? It's like a cactus flower. I actually had a student last year who participated in this ceremony. I don't know how he write that out from the bar exam, but you have to. Does Texas bar require you to disclose your drug use? Virginia does. I don't know. You want to check on that. But the Virginia bar requires you to disclose any drug use. Not even drug arrest, drug use. Was that?
Because everybody's going to be really upfront on that.
Don't lie on that one. It's much better to tell the truth and explain than to lie, because then you won't become a member of the bar.
Oh, I'm not saying lying, but I'm just saying I doubt most people are being upfront about that.
Well, that's called lying.
I'm not condoning lying on it. I'm just doubtful that most people are.
Well, you should be honest on your bar form. You should. That's something you never recover from. If you lie in your bar form, you may be disbarred for life. Even if you admit you broke a law, it's much better to do that and explain it than to actually be caught in a lie. Always, always. Always disclose it. You can explain it away. If you lie, then your integrity is gone. Reputation shot. So in this case, Mr. Smith used peyote, which is a hallucinogen. It's a controlled substance as part of his religious sacrament. He was terminated from his job in part because he was using this illegal drug. So he applied for an unemployment benefit from the state of Oregon. That's what the employment division, the employment division of Oregon is. And he was denied the benefit. Why? Because he was terminated for misconduct. And if you're fired for misconduct, you are not eligible for unemployment benefits. Now, what was I up to? Renee, how is this case different from the Sherbert-Verner case, the Seventh-day Adventist case we talked about a few minutes ago, where you had the Seventh-day Adventist who wouldn't work on Saturday, and then he was denied unemployment benefits? How is this case any different? Or why is this case different? Exactly right. Or at least this is how Justice Scalia describes it. Whether it's right or wrong, we can discuss. So at issue in Employment Division versus Smith is what we call law of general applicability, right? Everyone is prohibited from using peyote. The law applies to everyone equally. It's illegal. It's a controlled substance. And there's no doubt that the state of Oregon can criminalize the use of certain substances. There's no doubt at all. Okay. In Sherbert, the Seventh-day Adventist case, the underlying conduct of worshiping God on Saturday was lawful. There was nothing unlawful about worshiping your deity on Saturday. With Smith, the conduct was unlawful. So it's on this basis that the court draws a distinction. A law of general applicability, which makes something illegal, the peyote crime, that can be enforced. And the state is not obligated to create carve-outs or special exceptions for religious groups that want to use this sort of peyote in their religious sacrament. So although Smith didn't really overturn Sherbert v. Werner, it read it really narrowly. So narrowly that so long as the law is framed generally enough, you're not getting religious accommodations for it. So while the Seventh-day Adventists got an accommodation so that he didn't have to work on Saturday, the Amish got accommodations that they weren't required to go to high school. In Smith, a 5-court decision that's been very controversial, the Native American could not get an accommodation for using a controlled substance.
Question.
Yes, Hanzo.
So does that mean then that regardless of the impact, if the intention was not to be discriminatory toward one group, that's the test that they're using?
Yes. So let's jump in. I'll come back to Smith in a bit. Janine, tell me the facts of the Church of Lukumi Babalu Aye. My favorite case names.
I don't think I read that one.
I signed it, right?
Oh, the Church of the
Yeah, that's what I said.
Sorry.
How do you say it? I emailed with the head. I don't know what you call it, the leader of this church. I was supposed to go to Miami. I wanted to interview him. It never came together. But I actually obtained a few emails with this guy years ago. Interesting guy. So, Judy, what were the facts in the Church of Lukumi? It's okay. Yeah, I think it was a short blurb. I only gave you the full case. Want to try it, Andrea?
This one is where they were making animal sacrifices.
Oh. Okay, so everyone knows what the Santeria faith is, right? It's an Afro-Caribbean faith, and one of the sacraments involves animal sacrifice. And they actually take a chicken, they slice the chicken's neck. There's a lot of blood. Okay. Andrea, what law did the city of Hialeah, Florida enact?
They enacted a law of general applicability that
What did the law prohibit? Michelle?
So the ordinance wasn't neutral, was the whole issue, because the city ordinance.
What was the ordinance? What did the
They
ordinance
said the
say?
city ordinance specifically targeted Santeria religion and
What-
made animal sacrifices.
What was the ordinance? Just forget to the pretext, but what was the ordinance itself? What did it actually prohibit?
killing an animal.
Mark?
It prohibited killing an animal in a religious ceremony except for like food consumption.
Did the statute have the word religion in it? Kill?
It's an unnecessarily
Yeah.
killing.
Private public ritual.
Okay. Well, but was the word religious anywhere in the statute?
There was no reference to
Okay.
religion.
So this is why I want to juxtapose Smith with Lukumi, right? The law basically said there are no unnecessary killing of animals. On its face, right, the law said nothing about Santeria. It said nothing about religion. But Michelle, why was the court suspicious of this law?
Who else would it apply to?
Yeah.
Thank you.
So this made the court suspicious, right? So on its face, the law looks neutral. There are exceptions for butchers, right? There are exceptions for commercial, whatever. This would only apply to a specific group, which was very prominent in South Florida, that was engaging in these ritual sacrifices of the animals. So the court said, this is not a law of general applicability. This law was enacted to directly target this group. And because it was meant to target this group, it was invalidated under the Free Exercise Clause. So ever see the difference between a law of general applicability, right? A law banning controlled substances applies to everyone equally. It was not meant to punish or to target Native Americans. In contrast, the Florida law, the Hialeah, Florida law that prohibited killing animals in a certain manner looked neutral on its face, but meaningfully only applied to the Santeria Church. And as a result, the court found that it was targeting, and it singled them out.
So if we go backwards, then Yoder, the state law, was then considered neutral because it applied to everybody.
So why did the Amish win in Yoder? Shouldn't they have lost under the Smith rule? This is why I said Smith effectively reversed the rule from Yoder and Sherbert. It didn't come out and say it, but it did. Right? So Smith altered the free exercise landscape. Again, this was Justice Scalia, right? Who was viewed by many as conservative. Why is he having this decision on narrowing religious freedom? Well, to go back to the point we made before, who are the kinds of people making religious liberty claims? Well, you had the Amish, you had the Seventh-day Adventists, you had the Indians, right? Peyote. Who cares? Whereas today, things have changed suddenly, and different groups are invoking the protections of free exercise. So let's put a little bit more time on Justice Scalia's opinion. Why is he okay with laws of general applicability? He effectively says there's no evidence that anyone's being targeted, right? They're not trying to single out any religion. And this part of the opinion actually, I think, makes some sense. We cannot have a legal code if every flying spaghetti monster gets an exception from it, right? We usually don't give exemptions to the law based on what someone's religious beliefs are. So Scalia is okay with the political process carving out any necessary exceptions. So he walks through a number of cases, one called United States versus Lee. In that case, an Amish employer sought an exemption from Social Security tax. The Amish actually, their faith prohibits government support programs. Cameron, why do you think the Amish can be excused from schooling? They're teenagers, but they won't be excused from Social Security tax. Well, why can't they get a tax exemption? They're not going anywhere. What do you think? Cameron, what do you think would happen? What do you think would happen if a group suddenly got an exemption from the Social Security tax? Or, let's say not. Let's say that just Amish were exempt from it. What do you think would happen? No, what do you think, Roy?
Oh, so I was thinking, hold on.
Yeah, don't be on the Amish. How does Social Security tax work in theory, at least, not in reality?
You pay in when you're young. And
Everyone pays in, right? If groups started to stop paying into Social Security, the entire thing would implode. So the court effectively said, right, that the tax system cannot function if groups were able to seek exemptions from it. Or let me ask you a different case I mentioned a while ago. Bob Jones University. I think I mentioned this a week or two ago, right? So you had a university that had tax-exempt status, and they prohibited interracial dating. They actually allowed minorities in, but after some cajoling, but they refused to allow interracial dating on campus. And they challenged revocation of their tax-exempt status. And they said, it goes against our faith to have blacks and whites intermingling. It's sinful. How's that case come out?
how did it come out, or how should it happen by doing it?
Either one.
Well, you would think how they would roll on that, based on what we're reading, is that they would say that because what they're doing is so wrong.
What's the state's interest, Roy?
No compelling, basically bigotry.
What is the state's interest? What is the state's interest in taking away the tax-exempt status of the university? What are they trying to do? Sending a very clear message, in fact.
Yeah, they're expressing their views about interracial. marriage.
What is the state's interest? You're dancing around the question. What's the state's interest?
Keeping.
Jared?
State interest for.
Taking away the university's tax-exempt status.
I think it would have something to do with just kind of keeping going like, I guess the status quo for the state.
No, wow, this is easy. Nikolai, what's the state's interest here? What's the state's interest in taking away the tax-exempt status of a school that bans dating interracial? This is the exam material, guys. You have to know what the state's interest. You have to be able to articulate this stuff. You got it, Nikolai? Yes, to try and end segregation and discrimination, right? By taking this away, they're making it very expensive to have segregation and discrimination. So the state does have the compelling interest in rooting out discrimination? Yeah. Therefore, the state's compelling interest trumps. Okay. Therefore, right. Okay. The state's interest in rooting out the segregation and the discrimination is compelling enough that it actually trumps. It trumps the religious liberty claim. So always in these sorts of cases, you have to balance what is the state's interest and what is the interest of the adherent of the belief. Okay. All right. Answer question of Justice Scalia's majority opinion. Anything else in Scalia's majority opinion?
I do have a question.
Yes.
So Scalia obviously wants to leave it to legislation to decide these carve-outs, or if the society wants to make these carve-outs.
Right.
Okay, so then Congress obviously got really pissed off and created RFRA.
I'm not going to get to it in a few minutes.
I'm sorry.
I'll get to it in a few minutes,
Well,
I promise.
Okay, so but I guess what I want to go back to, and maybe if I'm getting too deep, please say so. So do we need to worry about for the test what Madison's intentions were?
You need to know
say?
everything for the test.
I know.
I'm not going to answer that one.
Okay,
Roy.
well then I'll ask it. So.
Okay. Sorry.
So
Go
then I'll
ahead.
ask it. So where would Madison square himself?
You tell me.
On what side?
Where would Madison be on
I
this?
think he got caught up is that he didn't want the states or even the federal government getting involved with this.
You think
duty.
Madison would have wanted to give carve-outs to religious groups?
No, I don't.
So Madison and Scalia were on the same page?
I guess so. I don't know. I mean, because at one point though, you listen to this of how, I mean, the whole point of the thought of wanting religion though, and protecting it was to have this morality and it was so connected with our society and how we were as a nation.
Mm-hmm.
But at the same time, that's what was going on in Yoder, that here the state was requiring an action that was inconsistent with your belief.
This line of cases is frustrating because it's very inconsistent, which is why it's a hard topic to teach.
Okay.
It's not like, hey, Mark?
So this case didn't overrule Yoder? did it?
Not
It just-
exactly, but it basically reduced Yoder to not meaning too much. And I think the distinction Scalia offers is that the conduct in Yoder and the conduct in Sherbert were lawful, whereas here the conduct here was unlawful. But doesn't it just circle? Because the fact that they made it unlawful means they weren't concerned with the religious claim in the first place. Yeah, Roy?
You just asked the question to us about the, I guess, a compelling state interest, but Scalia, if I'm not mistaken, takes the time to go through two or three different analyses. He goes through the Sherbert test, compelling state interest, and he basically seemed like to me said that they're really not applicable, and they're not useful in measuring this.
Why?
Well, For the government compelling government interest on 1119, right in the middle of the page, he basically says any society adopting such a system, and it seems like he was referring to a system using compelling state interest, would be courting anarchy.
Yeah.
So
Scalia, here I'll get you in a second. Scalia's point is that this allows discrimination, right? That this gives a license to judges in particular, the ability to carve out and chop up laws and create exemptions for different religious groups to discriminate.
So what is his test?
Chibi hands up before. I'm going to try and answer it. So what is the test? So what is the test, Michael?
Well, I think what the issue or what he's trying to say is that it's not appropriate for the judges to determine the centrality, because in order to apply the test is how compelling the government interest is on one side, they're having to weigh it against this religious conduct or belief. And so now the judges are trying to determine, is this really valid, or is it, how important is this belief? Well, it's not for the judges to determine that, is what he's saying.
Debbie, I think your hand was up too.
Yeah, I guess I thought that there was that it belongs to the legislature, not to the court, right?
That's political process, right? All legal process shake this out. So let me,
So is Scalia really saying that he has more faith in the people
yes,
versus the court?
that's exactly what Scalia is saying. He's saying that the people are in the best place to make decisions about religious carve-outs. And if the people want to carve out certain religious beliefs, they can. And if they don't, well, then too bad. So effectively, Smith eliminates the judicial role in the Free Exercise Clause. The only question under Smith, the only test they have, is this a law of general applicability? If the answer is yes, the court's hands are off. If the answer is no, then you go to the Church of the Lukumi, and you can see if there's a pretext, if there's actually a discrimination involved. The effect of Smith, and again, this is a very controversial decision, was to eliminate the courts in the Free Exercise Clause analysis. Gone. And the irony that now various religious groups are seizing on the Free Exercise Clause, that was a Scalia opinion that nuked it, has not been lost on many. Okay, let's go on to the dissent. What was I up to? Jennifer, what did Justice O'Connor say in the dissent?
O'Connor pretty much said that the majority just automatically said the general law was applicability applied, then the First Amendment didn't apply. But then she was saying that that you should use they usually keep the government satisfied with the state interest.
Yeah. So O'Connor would stick with the Sherbert v. Werner test, and she basically says Scalia's attempts to distinguish why Sherbert and Yoder and others aren't very persuasive. And O'Connor says, you know what? Yes, it's dangerous to allow courts to try to be the ones to carve out exemptions to generally applicable laws. It's dangerous, but it's better than the alternative. I mean, she says it in no uncertain terms, right? That the First Amendment was enacted to protect the religious rights of religious minorities. Views not shared by the majority will be met with hostility. The views not shared by the majority are the least likely to obtain legislative protection. And O'Connor would reserve this for those exact circumstances. That she trusts courts to be able to create carve-outs, accommodations based on religious conscience. Even if there's effects on third parties, even if the children of the Amish aren't getting educated, even if people are using drugs, and drugs are bad, okay, right? Even if drugs are bad. She's comfortable with that role for the courts. So I think the big divide between the majority and the dissent is whether the legislative branch should be trusted to provide these sorts of accommodations, whether the courts entertain a role to intervene when those carve-outs are not created by the state. Question about Justice O'Connor's dissent. Anything about O'Connor's dissent? So what happened after Smith is actually very interesting. Back in the days when Congress passed laws, there was actually a very swift reaction. Indeed, this was a bipartisan reaction. For the most part, this decision was not well respected. Religious groups from across the aisle, you had Jews, Muslims, Christians, all uniting and saying that this decision was awful. Why was this decision awful? Because it allowed the state to discriminate against religious organizations. So Congress, in a basically unanimous vote, it was introduced in the Senate by Ted Kennedy, introduced in the House by then Representative Chuck Schumer, when he became a U.S. Senator, the Religious Freedom Restoration Act, or RFRA, if you want to be cool. RFRA was enacted, signed into law by President Clinton. It was almost unanimous. There were almost very few votes against it. I think it had a voice vote in the Senate. I think it was a near unanimous vote in the House. So what did the Religious Freedom Restoration Act do? Complicated. At a minimum, what it was meant to do was to restore the test from Sherbert v. Werner, the Seventh-day Adventist case. At a minimum, it was meant to restore the test from Sherbert v. Werner. Did it do more than that? It's complicated. What makes it so complicated is that when you try to reduce a judicial opinion to a statute, you often miss some stuff. So what the law effectively says is that the government wants to impose a, quote, substantial burden on religious exercise. If the government wants to impose a substantial burden on religious exercise, they must show that it was done with the, quote, least restrictive means. The most least restrictive means. What does this mean? Well, if they can accomplish this goal without burdening religion, then they ought to. The final element is they must show a compelling governmental interest. They must show a compelling governmental interest.
Would this be similar to just being narrowly tailored?
Yeah, it's the same thing, right? So so Caleb, let's look at Smith. What if Smith had been brought under RFRA rather than the First Amendment? So first, did the denial of benefits on Smith for using the KOD, did that impose a substantial burden on religious beliefs?
The denial of unemployment benefits would not have burdened his religious beliefs. No.
Oh, he says, sure. He says, I'm basically forced for the choice. I can either keep working or not practice my religion.
He can practice it, even if he doesn't receive unemployment benefits.
Right, but he'll be fired for doing so. Make it easier. Let's say he was fired for using the peyote. And it's a state job.
I mean, I guess I don't see the connection between your ability to practice or believe something and
That
employment.
he would it impose a burden on him if faced with a choice? You can keep your job or you can stop doing your religious ritual. You not see a burden there?
It's a burden, but it's not an undue burden.
Ooh, the word substantial. What do you think?
Well, didn't the court say that that sacrament or whatever was a big part of the religion?
It was central.
And
So central.
that to me would place an undue burden.
Isn't it interesting? So even in this class, people disagree about the burden. What do you think? Is that a substantial burden on his belief that he has a choice? He can either keep working or give up his keep working, give up his faith, or keep doing this religious, and he has to give up his job.
I mean, I think it's because you can work any day of the week. You don't have to work on Saturday. You don't have to work on Sunday. You don't have to work. Lots of people have alternative schedules. And I was thinking of this, if you're like, if you were like a highly specialized person, like a doctor, and you were in school for years and you just can't work on Saturday, I think you could make an allowable, you make an accommodation. But like the people who work in retail, who work in non-specialized jobs, they have alternative schedules. There's
I'm talking about peyote here, not the Saturday work.
I thought you referenced the.
Okay, you can talk about that one.
Oh, well, I mean, the peyote, I think, well, anyway, to finish, I think you can make an exception in the sense that people can work it in. With the peyote case, I think it is a heavy burden.
Well, it's a heavy burden on whom?
On him,
On Smith.
on Smith, now to be able to use it for.
Okay, so is there a least restrictive means by which this? Okay, so there's a substantial burden. There's a state of compelling interest in criminalizing drugs.
Criminalizing them? They do,
Okay.
they do.
Could the state achieve that interest with the least restrictive means that wouldn't burden its faith? How?
By giving him the exception.
I think they're
No, I think this is it a burden? Yes, but further something that is very compelling to the state interest. And there isn't any other way of making it less restrictive because you have to generally apply it, and it comes similar to like in CITPO, how courts determine a form shopping. It's a very parallel argument. Is that then if I want to use peyote, then I could just pick up this religion and.
But then would it be substantial? It goes to sincerity, right? Is a belief sincerely held?
Well, I'm saying in this essence, I think it's as little restrictive as you can make it. I mean, you have to make that.
Well, I think, I kind of disagree because you said during Prohibition, they were allowed to use sacramental wine, but they weren't allowed to take sacramental wine outside.
In other words, Nuri, let me ask you, would the state's ability to enforce narcotics laws crumble if an accommodation was made for Native Americans? So could the state still compel, punish narcotics if they allowed, a few Native American tribes to do this daily? So isn't there a least restrictive means that can still achieve the compelling interest? And that's a test, right? Can you still achieve that compelling interest with least restrictive means by maybe carving out a few groups? RFRA does what Smith didn't. RFRA allows courts to intervene and say, wait a minute, can you do the same thing you're doing, but, with this carve out? And the answer is yes, and the court orders the carve out. Court orders the exemption. So there's actually a case called Ocentro. It involved get this wrong. I think it was a Latin American Indian tribe, and they used this hallucinogenic tea as part of their sacrament. And they brought suit under RFRA. The exact same facts as Smith, right? And the court ruled in favor of the Indians, saying that because the state could create a small exception for this limited group, only one group used this sort of tea leaf, and imposes a substantial burden, give them the accommodation. So RFRA stepped in to create, exemptions by the courts. Michelle, you hand us up?
Yeah, drinking sacramental wine has nothing to do at the end of the day with the Mass. You can still participate in the Mass. You don't have to drink the blood of Christ or even take the host. It's not required in a sense to, practice your faith during the Mass. So all these.
Do some people do use it?
Yeah, but the point is that if I did
does that have to be required by your faith, or maybe some people like it?
No, it's not required. That's my point. When there's been really bad illnesses, it's been known for churches not to even give the blood of Christ.
Or if someone's gluten free.
I'm just saying I don't.
Actually, apparently they have gluten free hosts now. I'm aware of this.
I'm just saying it again. I don't think it gets to the core of what has been said earlier. Is that
it's not central.
It's not central to your faith.
So in fact, the peyote is more central to the Indian faith than the sacramental wine is in the Catholic faith. Is that it?
Well, I just don't think the court should even try to get into the mix of deciding.
So you're a Scalia fan.
What's more sacramental versus the other? I think it's.
Let's try hand somewhere over there. Yeah, Janine.
Okay, so I'm a little confused.
Yes.
With the payout.
Yes.
And the state interest and the federal government's interest in regulating narcotics.
Yes.
If it's a compliance issue and you have a job that's related to safety or different things like that, I think the compelling interest that the interest of protecting the citizens based on whatever safety issues or based on criminalization of a narcotic, however you want to put whatever statute together for it. There's not a way to narrowly tailor that for one group, because then that is just going to be.
You letting your people,
Yes,
public
no.
employees, exposed to people on drugs.
Right, and then the snowball effect is gonna be, you're gonna have the church of the flying spaghettis all of a sudden wanting.
Well, there's a
to
church of the
smoke marijuana
cannabis.
all the
I think
time.
there is a church of cannabis, and there's actually a group in Indiana, I think, who said that cannabis is their a holy ritual.
Right, so.
What hath RFRA wrought?
Is this what
Right?
RFRA is?
So was Scalia right? And this is where I wanted the discussion to lead, Janine. Your question was well timed. What hath RFRA wrought? Smith was basically saying we should not have the courts involved in carving out exemptions for religious groups, because this is madness, right? How do we allow these groups to just make stuff up? If they do it enough, become satirical, then we have to give exemptions to the law. Congress, and in fact, about 20-something states, said this is wrong. We want to enact RFRAs, we're called baby RFRAs, where states enacted RFRAs. Also, Texas has one. And they all say, like I said with Nuri a minute ago, if there's a practice that imposes a substantial burden on religious exercise, the state cannot enforce a law unless they find that there's no other way of doing it, that there's no least restrictive alternative. So the debate over RFRA was originally involving Native Americans smoking peyote, or the Ocentro case, hallucinogenic tea. And I asked you to read this article, which I wrote last year while I was teaching ConLaw, about Indiana. And there was so much misinformation about this case, if you remember it. I wrote this article, and it got like, I don't know how many hits. I did like 10 interviews like in 2 days, because I was the only person actually studying this. But I was on NPR and Fox News Radio to make it balanced. I was on both, okay? The issue in this case was whether RFRA allows for discrimination. And I think that's the wrong way of looking at it. So RFRA says if the state wants to take action against you that imposes a substantial burden on your religion, they must prove that there's no other way of enforcing their compelling state interest. So where does this come up? I'll give you an example. This is actually a very sad example. So did I mention the organ transplant issue? Did I mention this? Okay, so I think there was a person in Nebraska who was a Jehovah's Witness. And a Jehovah's Witness cannot do blood transfusion. It goes against their religious beliefs. There's actually a lot of case law on this. This person needed a transplant. I think it was a kidney or a liver. I can't remember what organ it was. And in the state Medicaid system, the only way of giving her this transplant would have involved a blood transfusion. So she refused to take the transfusion. She was going to die. She discovered that the next state over, I think it was Kansas, whatever, I can't remember what it was, allowed for a procedure under their Medicaid that gave a bloodless organ transplant. I don't know how this works, but you can basically do a organ transplant without a blood transfusion. Modern medicine, wonderful. But her state's Medicaid did not cover this. So she actually brought a suit under the state RFRA, challenging that to give her the blood transfusion would be a substantial burden. And look, the state can give her the service, at an additional cost by sending her across state lines. And this went through the courts, and eventually she won the case. The Supreme Court of the state ruled that under the state RFRA, requiring her to undergo the blood transfusion would impose a substantial burden. But unfortunately, by that point, it was too late, and she was only a candidate for the surgery. I think she died. But RFRA wasn't designed as a tool for discrimination. By the way, Selena, right? We're in Texas, Corpus Christi, right? She was a Seventh-day Adventist. And one of the reasons she died was because her family refused a blood transfusion for her after she was shot by that woman. Everyone saw the J-Lo movie? Yeah. So, I realize I'm close to the Astrodome. I knew nothing about Houston, Texas my entire life except for the Selena scene, the Astrodome. I only knew about Texas and growing up. But one of the aspects of RFRA is it applies to all sorts of state action. And one of the forms of state action is actually anti-discrimination laws. So what happens if someone brings a lawsuit against, I'll give you an easy example to start with. Let's say a school in the District of Columbia, Catholic University, a religious school, refuses to let men and women sleep in the same dormitory. They have married dorms, but if you're not married, you can't sleep in the same dormitory as a person of the opposite sex. Under most RFRA laws, under most discrimination laws, you can't discriminate on the basis of gender. You can't. There's no carve out. So a lawsuit was brought against Catholic University, and let's say RFRA was raised as a defense. What do I mean by that? Someone sued Catholic University saying, I want to have my dormitories with people of the opposite sex. There's a discrimination claim, and then Catholic University raised RFRA as a defense, saying that imposing this law against me poses a substantial burden on my faith. Would this be allowed? I'll give you a different example. Let's say the church, the Presbyterian Church of Connecticut imposes a mandatory retirement age of priests, saying that priests must retire at the age of 70, whatever it is. Okay, so a priest reaches 70, he gets terminated, and then he brings a suit against the church saying you're violating age discrimination law. The state says you can't discriminate against older employees. In fact, every state has a similar law. The church says, as a defense, I am raising RFRA. We have an interest in having young parishioners. It would burden our faith to require us to keep old priests. That work. So while usually most employers would not be able to defend against an age discrimination claim, RFRA would seemingly allow just such a claim. Now what happened with Indiana, I can't believe it was a year ago, so 6 months ago, whenever it was what if this wasn't a church or a university, but a private business? And a gay couple walks into a florist and asks the florist to design a bouquet and flowers for their wedding. And the florist says, I'm sorry, I can't provide the service to you. And then the couple brings a suit under the state law which prohibits discrimination on the basis of sexual orientation. Could then, like the church or the university, the corporation, raise RFRA as a defense to this case? So the first threshold issue is one that was resolved in the Hobby Lobby case, that is free exercise limited to churches and schools, or does it also include for-profit corporations? And this was a very controversial decision, a 5-4 case from about 2 years ago. And there the court held over bitter dissent that the mere fact that you take the corporate form, much like free speech perhaps, does not deprive you of your free exercise rights. So for example, the Hobby Lobby Corporation, although it has nationwide chain stores in every state, the company is actually held by a family, a single family, and it's actually held in trust. There are no shareholders, and virtually everyone in the family holds the same beliefs. Funny story, but after I wrote my book, I sent copies of the books to all the justices, and actually none of them wrote me letters back, and I got all the letters framed at Hobby Lobby, including Justice Sotomayor. You should be laughing, but it's okay. It's late. Class is almost over right now. Get out of here, Blackman. We finish up, right? So the issue there was whether private businesses are able to raise RFRA as a defense. This is a largely untested area of the law. And indeed, when I was discussing HERO, our favorite equal rights ordinance, which you won't hear about till after the recall election, then we'll start hearing about it again. I'm sorry, the runoffs. Then we'll start hearing about it, because once the runoffs are done, then they can start saying what they actually think. The issue with HERO was if the same thing happened at a university, St. Thomas or whatever, if a church turned away a person based on their sexual orientation, gender identity, could they have raised the Texas RFRA as a defense? That's an open question, and I didn't quite know enough about it, but I think it's an open enough question. But let's assume that they can raise it as a defense in a discrimination claim. At heart, what happens is that the courts would be able to start crafting out, call it an accommodation, or call it an exemption to a discrimination law. Let's talk for a minute about Kentucky. And I mentioned this example in class before, but Kim Davis, whose case is mostly misunderstood for the most part, what she actually requested was not to turn away gay couples. What she actually requested was an accommodation. She wanted the form to be modified so that her name wasn't on it. Okay. After a burgerful was decided, the Texas Attorney General released a letter, which people, I think, again, misread. And it basically said that if you're a Texas state employee and you object to participating in same-sex marriages, you can request an accommodation. Now, that doesn't mean that gay couples won't be able to get licenses, or even there'll be a delay. It simply says if there are 5 people in the office and one person objects, put that person on, property taxes instead of marriage licenses. You can see the concerns of Justice Scalia in ways he perhaps didn't quite anticipate. That once you start saying that if a law imposes a substantial burden on your beliefs, you start carving out these exemptions and accommodations. And it's my sincere prediction that I think states will begin repealing the RFRAs. I think we'll see Connecticut maybe first. You can quote me on this in a few years. But to the extent that these laws start being used as a way to carve out exemptions from various laws, I think either A, courts construe them really narrowly to the point of not even existing, or B, states just legislative repeal RFRAs. Janine.
Even if RFRA, oh, I formulate this question. I don't understand the reliance on RFRA when you could just bring a claim under First Amendment or 14th Amendment.
What's the First Amendment claim?
A free exercise under that.
But what is the meaning of the free exercise clause? Who defined it? What case do we have telling us about the free exercise clause? What case do we study today? Smith. Smith is still law, and I forgot to mention this point, but it's important. Smith is what the First Amendment means. Until the Supreme Court overturns Smith, that's what it is. And the First Amendment only protects laws of general applicability. Now, the part I didn't mention, there's a case called Burney v. City of Flores. You know that case? The Supreme Court invalidated RFRA as applied to the states. Why? Because RFRA attempted to redefine the First Amendment. RFRA attempted to say, you know what, Scalia, stuck it. You're wrong, right? We're going to define what the First Amendment means. And what did the Supreme Court say? And this was, I think, 6-3 or 7-2. No. We, the judges, get to decide what the First Amendment means. Not you, silly Congress. Not you, we the people. The Supreme Court. It was the Supreme Court that gets to define the First Amendment and not Congress. Isn't that a perfect place to leave the semester, right? Isn't that a perfect place to wrap up? That the Supreme Court issued a decision saying what free exercise religion means. Congress passed a statute saying, no, we disagree with you. We want to provide more protection for religious liberty. And then the Supreme Court intervened and said, nice try, guy. We as justices get to decide what the meaning of the Constitution is. There's perhaps no more palpable tension in the last 50 years than this sort of case, where Congress tried to provide constitutional rights that the people and the representatives nearly unanimously, Bill Clinton and Orrin Hatch and Chuck Schumer and Chuck Grassley all agreed on this.
Okay, so why didn't Scalia see that as the political process working then? Why couldn't he just accept it?
I think the reason why, Scalia would have been okay if they enacted statutes that provided statutory protections. But here, they intruded on their turf. That those lowly members of Congress crossed First Street from the Congress to the Supreme Court They're right across the street. The Supreme Court and Congress are literally across the street on First Street. It's a good analogy going back and forth. But the court said you are intruding on our turf, that we have a monopoly on deciding what the First Amendment means. And I think I started the very first day of class, or maybe the second class, saying, why do people obey courts? Why do people listen to courts? Where does the Supreme Court get their license to decide what the Constitution actually means? And the exact same problems we had on the first day of the Republic persist till today. Any questions?
I have one quick question.
Your hand was up first. Go.
For Scalia, in the case we just talked about Smith, said it was a criminal conduct. That was his justification. But so how would he feel about Kim Davis carve out? Like, so that's what I'm trying to apply this to other cases.
So, but Scalia would say Davis gets no car.
Different.
Is failing, well, is the act of not issuing the license criminal? No, that's a question. Is it?
No. Someone else can.
The answer is it's not, right? And this is the part that the opinion is widely misunderstood. There's no obligation to actually have one person handing out the licenses. Also, RFRA is part of Kentucky's law. So to say that her actions were illegal ignores RFRA. Kentucky has a RFRA, and under Kentucky law, before you say her conduct's unlawful, you have to consider whether an accommodation be given. It is very circular.
I'm studying for the. Yeah, so what I'm saying is, if I'm using Smith as my case with this law, for First Amendment, that's what you just said, for freedom of religion, how does Kim fit into?
Kim doesn't cite the First Amendment. She cites RFRA. Davis does not cite the Free Exercise Clause. The Bakers do not cite the Free Exercise Clause. The Florists do not cite the Free Exercise Clause. All these cases, state RFRA or federal RFRA. Not all states have them. Roy, your hand was up also?
Sir, you mentioned in the article the Elaine photography versus Willett, and that the Supreme Court had declined to review the case.
Yep.
What more? So, and when you mentioned a second ago that they'll either so narrowly read it, but it sounds like to me you're not even going to address it. You're not even.
Well, interestingly enough, Elaine photography is a free speech case, not a free religion case. Yeah. So what's interesting is that cases brought under state RFRAs are not good vehicles for Supreme Court review because the state court of last resort is the final interpreter of what state law means. So if the New Mexico Supreme Court finds that the RFRA only goes so far, the Supreme Court can't reverse that. So that's why Elaine photography was actually a First Amendment free speech case where the court can intervene. But again, what I said before, states will start interpreting the RFRA so narrowly to effectively wipe them out. Other questions? Going once? Yes, Jenny.
So why don't individuals raise as a defense instead of raising RFRA as a defense, raise their First Amendment?
Because Justice Scalia said it doesn't matter. In Smith, so long as it's a law of general applicability, which discrimination laws are generally applicable. They apply to everyone equally. You can't. You're going to lose. You can raise it, but you're going to lose. Smith is effectively rendering the First Amendment a dead letter unless there's targeting of specific religious groups like in Lukumi. What else? Going once. Going twice. Thank you. Oh, wow. God. I don't know. If you email me, I'll try and get back to you as quickly as I can. Anything else? All right. Thank you all for a great semester. Appreciate it. Thank you so much.
Yeah, this wasn't by accident. It's this article.
I don't remember. What day's review?
December 2nd.
Second.
6th. Right.
The review is on the 2nd at 6 p.m.